Okay, let's talk about themes. I need your guys' input here. All right, you get a case, and it is a, maybe a rural farmer, and he or she is being sued by this multinational corporation that is looking to take over his land. Give me some ideas what themes you might come up with in that particular case without having to know much more. Yes, sir?
Probably greed.
Could be greed, okay. What others? It's a good one. Greed's always a good one. Yes, sir? David and Goliath. David and Goliath is always a great theme. Any other ideas? Okay, well, what about, yes, ma'am. I'm sorry? Taking down the man. You got to think, and the great thing about themes is that it helps provide something that your jury can relate to. So let's take the taking down the man. You're going to have to put together your case from your opening through your examinations through your closing around that particular theme, and you're going to need it to relate to your jury. If you don't think your jury's going to really get that, if that's say it's a genre specific reference, if it's not going to relate to your jury, you're going to want to come up with a different theme. So let's say it's a criminal case and the description of the perpetrator is fairly vague and ambiguous, but there's eyewitness testimony from a little old lady. Give me ideas. What theme might you come up with? No one can think of a theme for a case like that? Yes? The Big Bad Wolf. Okay, good Big Bad Wolf. Eyewitness testimony. That's the only thing that clinches, that brings the defendant as the otherwise very vague description. How about just mistaken identity? Or, you can, so the idea is that you can take these cases, take the facts of these cases, and try and package it in a way that relates to your jury. Now, the thing about using themes, it's more than just coming up with a theme and announcing it at your opening. That's kind of step one. But you really have to, if you're going to present a theme well, you're going to have to infiltrate it through your entire case. You're going to have to think about your theme when you're developing your cross-examination. What pieces do you need from a particular adverse witness so that in closing argument you can show how that theme, it's just along the same lines of that theme, whether it's the corporate greed or so on. So themes are critical, but using it in opening, have the same theme at closing, and then also using it through your examination can be a very effective way for you to tell your story. So I'm also going to talk about scoring because that matters, right? You guys want to advance. You have put all this effort, and we'll put all this effort into the case as it comes out. You want to do well. So each time that you do a role, whether it's a direct examination, direct and redirect being a package, or a cross-examination of a witness, or an opening or a closing, you have up to 10 points you can get from that particular presentation. So let me tell you what the scoring panelists are told about how to score. All right? So they are to score on 10 points. 10 points, 9 and 10 points, which is considered excellent. Uses notes sparingly for reference. Can assort essential from non-essential to use time effectively. Superior in the other categories that we'll talk about. So 7 to 8, above average. Exhibits mastery of the case materials. You know it, frontwards, backwards, can breathe it. It becomes you. Your communication is clear, organized, fluent, and persuasive. You can think on your feet. You're poised under pressure. This really is where your exhibits, or your objections come out. Uses notes sparingly. 5 and 6, average. An understanding of the case materials. Clear and organized communication, but could be stronger in fluency and persuasiveness. You can perform outside your script, but you have less confidence when you are away from your script. 3 and 4, minimally clear communication, minimally self-assured, lacks confidence under pressure. 1 to 2, poor. Unclear communication, disorganized and ineffective. Unsure of yourself, does not think well on her feet. Lack of preparation or understanding of the case materials. That's what the scoring panelists are provided with when they are scoring each time you stand up. Note that you might blow a complete examination. You might. But if you have another role, you could come up and be a 10 on the other role. It doesn't carry over. So each one is going to be judged independently of the other. One of the things you need to recognize when the scoring panelists are giving you those scores is they're going to score you when you are standing up with your mouth open and when you are sitting at the table. So if you are a witness and you fall out of character, or you're an attorney and you fall out of character, you might have done stellar when you stood up. But if you're slouching in your seat, and you're talking, and you're totally not you're distracted from whatever is going on, then you aren't. You aren't engaged, and you will lose points for that. So watch for that throughout the competition. Once the competition starts to the time it ends, you need to be in character. One of the things to note when you are selecting what order in which to call your witness is that you want to make a powerful first impression and you want to make a powerful last impression. Oftentimes you might select your most persuasive witness first and your most emotional witness last, but that's certainly not always going to be the case. But generally you'll select the witness that you feel is the weakest, either because of the evidence they have to present or because they're the weakest member as far as the portrayal of a character in the middle. So you want a jury to remember your first and your last. Jennifer brought up exhibits. So we're going to talk just briefly about when to use exhibits. You want to use exhibits when they're relevant. Okay, so we talked about introducing exhibits. If it looks like you're just introducing exhibits to introduce them, there is some credit to that. But if you don't know how to use them, so what point is it that you're going to be trying to make when you introduce that map? So if you introduce the map, think about what question you're going to ask about it next. So there's some relevance to using that particular exhibit. When you have exhibits, you know that you have the opportunity to ask for them to be published to the jury. You can decide if you want to have the jury have that exhibit in their hand at that time, which can be helpful when you're looking at a map. Or it can be very distracting when you're looking at a contract. If you give the jury something to read, what will they be doing while you're examining your witness? Reading it. So it's one thing if you give them a map that has a few little symbols on it and they are following along with that particular witness's testimony about where the rock was or where the, whatever is. But it is a totally different scenario if you're giving them some long document and they're just going to be reading it and not paying attention to you. Which leads me to a piece of strategy, and that is sometimes you might want to publish or ask to publish at the end of your examination because then maybe they'll read during your opposing counsel's presentation. So just an idea. Your choice. Last but not least, with respect to exhibits, use your exhibits if they're persuasive in closing argument. If there is something that is relevant about the document or about the map or about the picture, use it in your closing examination. My last remarks on this particular category before we move into the rules of evidence has to do with foundation and knowing how to lay foundations. The problem is going to come out in less than a month. After the problem comes out, you guys are going to be distracted by whatever it is that you're going to get. And you're going to be developing your character roles, and you're going to be working on questions and be thinking about objections. And you're not going to be thinking about, how do I introduce a piece of evidence? What are the mother may I steps? They're very straightforward. Yes? Right. There are very specific. First, you ask to approach anytime, and we didn't cover this specifically in the rules section, but anytime you want to approach the witness or the bench, you must ask for permission. Anytime you address the court, you have to say, Your Honor. You never, ever, ever talk to opposing counsel during the presentation. You only direct your questions to the judge, even if it's relative to opposing counsel. And you always stand if your mouth is moving, unless you're talking to someone beside you, but you stand up. Or unless you're the witness, or yes, that's true. Or you have a disability and you've notified us that you're unable to stand, in which case you'll be excused from the standing requirement. But it's not only just the dance that you must go through to introduce a piece of evidence, and you'll have it in your materials in those reference guides in the exact process. You also need to understand, how do you impeach a witness? There are some very specific steps. Have you asked the exact question that they talked about in their witness statement? Did you, go through the dance, basically, to present them, to give a copy to the opposing side, asking to approach, go on, so on and so forth. Impeachment can be a very strong tool, but you have to know how to do it right. And you have to be able to distinguish impeachment from refreshing recollection. Okay, so if I have a witness who gets up there and you're an attorney and your witness has just freaked out and forgotten what the witness statement is, and it's going to happen, your job as an attorney is to refresh their recollection, and you get to do so with their witness statement. But if you don't know how to do so, then you're not going to be able to help them out. You have to know that you're refreshing. You have to establish that they once knew it, that they can temporarily not remember it, that there is something that would refresh their recollection because they gave a witness statement. You're going to present a copy of that after you've shown opposing counsel, asked to approach, so on. You're going to give an opportunity for them to read it silently. Then you're going to get it back, and then they're going to testify about it. You're never going to admit it. You have to know those particular steps. So I would say impeachment, refreshing recollection, and introducing exhibits would be the three foundational issues I would be working on between now and the time that the problem comes out.